Hello everyone and welcome back to our channel. My name is AYUSH Kumar Singh. I am a legal intern in LEXIS and Company. So in this video we are going to discuss about Doctrine of Indoor Management. Under Indian law relating to companies, a public company is managed by board of directors which is entrusted with the responsibilities of managing the companies in the most efficient and transparent manner. Doctrine of Indoor Management, probably known as the Tackworth's Rule, initially arose from 150 years ago in the context of a doctrine of constructive notice. The rule of doctrine of indoor management is opposed to the rule of constructive notice. The latter seeks to protect the company against the outsider, while the former seeks to protect the outsider against the company. It is no part of a duty of any outsider to see that the company carries out the request internal proceedings. It is important to note that the rule of constructive notice can be revoked by the company and it does not operate against the company. It operates against the person who has failed to inquiry but does not operate in his favor. The rule of doctrine of indoor management has its gesture in English case Royal British Bank versus Tackworth. In this case, the directors of a company were authorized by articles to borrow on bonds of such a sum of money as should from time to time by a specific resolution of a company in a general meeting be authorized to be borrowed the bond under the seal of the company signed by two directors and the secretary was given by the directors to the plaintiff to secure the drawings of the current account without the authority of the such a resolution. Then the Tackwood sound to bind the company on the basis of that bond. Thus, the question arose whether the company was liable on that bond. Then Tackwood sought to bind the company on the basis of that bond. Thus, the question was arose whether the company was liable on that bond. The court exchange chamber overruled all objects and held that the bond was binding on the companies as Tackwood was entitled to assume that the resolution of the company is in general meeting has been passed. So there are some exceptions of the doctrine of indoor management. The first one is knowledge of irregularities. Second, negligence on the part of the outsider. Third, forgery. Fourth, no knowledge of articles. And fifth, act outside apparent authority. So now let's see what is knowledge of irregularity. When a person dealing with a company has actual or constructive notice of irregularity as regard internal management, he cannot claim the benefit under the rule of indoor management. So now coming on the second, that is negligence on the part of the director. When a person dealing with a company could discover the irregularities if he has made proper inquiry, he cannot claim the benefit of the rule of indoor management. The protection of the rule is also not available when the circumstances surrounding the content are also superstitious or as to invade inquiry and the outsider dealing with the company does not make proper inquiry. Now, forgery. The rule of Tackworth's case does not apply where a person relies upon a document that turns out to be forged since nothing can validate forgery. A company can never be held bound for forgery committed by its officers. So, now no knowledge of articles. This exception deals with the most controversial and highly confusing aspects of Tackworth's rule. Articles of association generally contain what is called the power of delegates. Now, lastly, acts outside apparent authority. If an officer of a company enters into a contract with a third party and if the act of the officer is beyond the scope of his authority, the company is not bound. In such a case, the plaintiff cannot claim the protection of rule of indoor management similarly because under this article the power to do and the act could have been delegated to him. The plaintiff can sue the company only if the power to act has in the facts been delegated to the officer with whom he has entered into the contract. So now let's see the position under Indian Companies Act. The provisions under the Indian Companies Act of 2013, which directly imbibes the Techworth's rule in section 1776, which read as follow: validity of act of delegates. Acts done by a person as a director shall be valid, notwithstanding that it may afterwards be discovered that his appointment was invalid by the reason of any defect or disqualification, or has terminated by virtue of any provisions contained in this act or in the articles, provided that nothing in this section shall be deemed to be given validity to act done by a director after the appointment has made shown on to the company to the invalid or to have terminated. So I hope you find the video informative, so please like, share and subscribe.